Also appearing for the Enid Child Support Office of the District Attorney's Office is Miss Melanie Bellinghausen. And Mr. Bernal is appearing in person, and Miss Amanda Reynolds is the custodial parent. Is that correct?
Yes.
Ms. Reynolds? Okay.
Yes, that's
All
correct,
right,
Your Honor.
And those are all the persons or parties for this proceeding, correct, Mr. Hammer?
Yes, sir.
Okay. Let me ask Ms. Reynolds and Mr. Bernal, do you need Ms. Bellinghausen sworn in?
Yes, I think probably be a good idea.
Okay. If the three of you would raise your right hand and let the court administer, do you and each of you solemnly swear or affirm that any statements or testimony that you give at this hearing today will be the truth, whole truth, nothing but the truth?
Yes.
Your Honor.
Yes.
Okay. Let the record reflect those parties have been duly sworn. I'll let Mr. Hammer make a brief opening statement. An opening statement is not testimony, simply to let the court and the parties know what the issue or issues to be decided are by this administrative court. When he's concluded his remarks, I'll ask each of you if you have anything else to add in the way of an opening statement. Again, I have no idea. Well, that's not true. I did pull up the file. It looks like this came on as a license revocation. Is that correct, Mr. Hammer?
Yes, sir. Pursuant to the notice of enforcement.
Well, let me give you this, because this probably is not applicable to an enforcement case, but for example, if you believe daycare costs, one of you believe daycare costs is an issue for this court today, then you, in your opening statement, you would say, Judge, I didn't hear Mr. Hammer say anything about daycare costs, and I believe that should be an issue. Apparently it's not an issue in this case, normally isn't, but that's just an example. You don't have to say anything. You can say you agree with Mr. Hammer's statement of the facts, you disagree, and once we've concluded an opening statement or opening remarks, and sometimes that's enough based on stipulations to resolve the matter. If not, neither of you are represented by an attorney, so I ask Mr. Hammer in those situations to inquire of each of you if he would like to do so. And generally, if he does, then generally that's sufficient to get a party's testimony before the court. If that's not the case, then both of you will be given an opportunity at an appropriate time to testify directly to the court. Mr. Hammer, I noticed you looking through documents. I don't believe any proposed exhibits or documents were sent to our office. If they were,
Yes,
I
he
need to
did
take.
send a copy of this.
There was a copy of the arrears computation sent.
Okay, give me just a minute. Let me see if I can retrieve those then.
I emailed them to legal aid.
What?
Emailed them to legal aid.
Legal aid.
Or, yeah, or legal OH. Like
Okay.
whoever would inform Mr. Stafford of this hearing.
Okay.
They were probably were they sent to Crystal Moore in our office?
Yes.
Okay. Let me see if she has those. Maybe she sent them to me back in the. Oh, okay. She did send them to me. I'm sorry I didn't get it printed off. Well, actually, I can read it on the computer, so then I can print it off afterwards. So we'll just continue on here. So let me get it right had that pulled up on the computer anyway, Mr. Emerson. All right, and that's the only document then that was sent that the court has, correct?
Yes, sir.
Okay, all right. Well, Ms. Kramer, I'll let you make your opening statement, and we'll go from there.
This matter does come on notice of enforcement and intent to revoke or suspend license based upon child support delinquency. State has one exhibit which has been forwarded to the court that we'll be asking to be admitted, showing what the current delinquency is. It will also indicate that there's a previous judgment balances of both principal and interest. We will be asking for judgment for the unpaid principal and interest since that time. We'll ask the court to be entering an appropriate order as to payment upon the judgment balance. I think that's where the parties have their largest disagreement here, is how much extra on top of current support should be paid. We're also going to state, and this is purely a housekeeping thing, we're asking the court to set cash medical support at 0. Based upon the income of the parties, that's what it would be anyway.
Okay.
But since it is not addressed in the previous order, we're asking that the court do that as well.
Okay. All right. Ms. Reynolds, do you have anything else to add in the way of an opening statement?
No, he's correct. It literally is just on the arrears that we're having an issue with,
Okay.
adding to some of what he pays per month for 3 children. They had suggested $20. I suggested $100 just because I know that that little bit will help him get caught up and prevent any legal recourses against him in the future, as well as help provide for our 3 children.
How old are the children?
Our oldest will be 11 in May 30th. Then our second daughter is 9. She'll be 10 in August, and then our son just turned 7 on January 20th.
Okay. So you child support will be due for some period of time then.
Yes.
Yeah.
Yes.
Be
There,
11 years until the 7-year-old emancipates at least, and
yes, Your Honor, due to the change in the law, the amount of interest, monthly amount of interest has dropped by $80 a month. Beginning November 1, the interest dropped from 10% to 2%. And that reduced the interest rate by 80% and the interest amounts by 80%. So at this point, prior to that change, the interest was actually over $100 per month. At this point, it's a little over $26 a month. So in order to really make headway, state will also be asking that the court set as large a judgment as possible. We'll give Mr. Bernal a chance to testify as to his living expenses and et cetera, if he wishes to do so.
Okay. So, Ms. Reynolds, do you agree? Do you have a copy of the record of payments, the arrears that the state says are owed to you?
No, I don't know.
Yes, I do. I have a copy of that, as well as I went to a public library before coming here, and I got a copy of what I can see when I log into my own account, as to how much he owes in arrears and interest. I didn't get a notification on the interest drop.
That's because the law changed.
Yeah, and I don't have any problems looking up the Oklahoma State statutes to find that law to verify that. Sorry, I did go to law school. I'm not a lawyer. I didn't pass the bar or anything, but
Well, I can tell you, Mr. Hammer is absolutely correct that November 1, the interest rate dropped to, from 10%
To
2%.
And our organization did fight that, but it didn't make any difference in the legislature.
but it doesn't affect before November of 2016.
No,
Is that
that's
correct? Oh, then I'm completely fine with that.
I do have, just for purposes of the record, Your Honor, I do have copies of that, which was of the exact same record that was faxed to the court. I don't know if what they have is that or not, but I do want
Okay.
the record to note that I am giving them copies. I will have Miss Bellinghausen testify as to this document, as to how it was drawn up and whether to its accuracy, and then I'll be asking that it be admitted to evidence.
Okay, with Ms. Reynolds and then Mr. Bernal's opening statement, I was just going to ask if she had seen that and if she agreed, just to see if there's a stipulation. It sounds like from what she had indicated, it's just kind of how much a judgment payment should be at this time that I may have misunderstood.
Oh no, I'm fine with the change. I just didn't know. I wasn't aware of it. And now that I'm aware of it, I actually think it's pretty justifiable for parents like James who had a hard time growing up, and I do reciprocate the feelings. I had a hard life as well. So this does help him,
Yeah.
as well as it helps our children.
Do you agree with the balance that the state shows on that document that you wrote?
Yes.
Okay. And, all right, did you have any, so the only issue for you is if Mr. Bernal agrees that's how much he owes, then it's just a matter of how much he can pay on top of current support.
Exactly.
Okay, so Mr. Bernal, do you have anything, any other issue that Mr. Hammer didn't discuss, or are you in agreement with
Yeah.
the balance showed on the schedule?
Yeah,
Okay,
I don't think that raising my child support case up, the amount would be any good interest. So I have 2 child support cases. I have another daughter with another case, and so both of those together. Currently unemployed right now, but when I do get employment, they take 65% of my income. So a $500 check can turn into $120.
how long have you been unemployed?
I do side jobs and stuff, but with the company, a year.
Mr. Reynolds, were you aware that he has been unemployed?
Oh, I know that he's actually been employed. As we were married, he did a lot of under the table jobs, and that's currently what he has been doing for the last year.
Okay.
I had notified him of a diagnosis of mine of congestive heart failure. And after I was diagnosed with that, I asked him to be a part of my living will for our children's sake, if you wanted to be a part of their lives. Start now. I would really love that. But he is currently employed. It's just under the table money that he receives. I've actually got photographs of it that I've shown to the lady here.
That's okay, he's not, I don't think there's I just wondered if you were aware that he's unemployed, because it appears like our only issue is how much a judgment payment should be, because the issue of current support is, this isn't a modification, this is an enforcement proceeding, so.
Yeah. I just want the arrears. Yeah, he has no arrears right now at all.
Well, it's,
And I thought $100 a month wouldn't be much because I'm the one raising the kids. I'm the one that feeds them and
sure, well, he wants to pay off that, I think it's $20-some thousand, is that correct, with principal and interest?
yeah, a little over
A
22,000.
lot of that was acquired while I was incarcerated in prison. I've always maintained my child support. Right before I went to prison, we had gotten a divorce, and the judge ordered for me to pay child support. So
Okay.
for 20, a lot of people don't have a case, child support case, because they're incarcerated.
I understand. I mean, we can only deal with the facts and law in your case.
Yeah.
And if there's been has there been an order reducing that amount or some substantial part of the arrearage to judgment, Mr. Hammer?
There is an outstanding, the state at least alleges there is an outstanding principal amount, unpaid, a previous existing judgment of $11,526.48 plus adjudicated interest of $2,171.62, and that would be through October 31st of 2013.
So are you asking this court today to for any accrual since then to enter judgment for that amount today?
Yes, and that information is set out on page 3 of the
Okay.
of what
But
will
it's
be
your
asked in court.
understanding that the parties agreed to the balance that's shown on the record of payments, correct?
I haven't specifically asked Mr. Bernal that yet, but that was my understanding, yes.
Okay, so there's a couple of issues, reduction of accrued judgment and principal to, it becomes a judgment by operation of law, but this is kind of a formality actually. If you were to present a copy of a check that everybody agrees you make that payment, then of course the agency and this court's going to give you credit, just as an example, Mr. Bernal. And I understand this law of child support, it changes from legislative session to legislative session occasionally. Sometimes it doesn't change for years, and sometimes it does, and the agency's policy sometimes, changes on, I know at one time the agency had a policy when a person was incarcerated to at least seek a minimum wage payment, which years ago was, I think we went from $63.50 to $108.50. I don't know what it is. I guess it's $222.50 today, isn't it, Mr.
For one child, yes. For
one
three,
child.
I think it is
At the same time.
$431.50 at minimum wage,
Yeah.
which is what it said in this case.
Yeah, but for a person becoming incarcerated, Ms. Reynolds, today, the agency's policy is to suspend child support until that person serves his or her time.
I'm sorry, Your Honor, I don't mean to interrupt. We didn't divorce when he went to jail. He went to jail for trying to kill me. He was incarcerated, and I filed for divorce to save myself and my children after his numerous threats on my life. I have tried to get protective orders against him several times. Finally, he got locked up, thankfully, but we were not legally divorced until September 17th of 2010, and he was only incarcerated from that date until January 6th, I believe, of 2012. And when he was incarcerated, he worked at a halfway house and was paying on his child support while incarcerated. I can bring up several cases to mention to date that still pay for child support as it collects in arrears as they're sitting in jail at the very moment that we're sitting here. And one of them is an ex-boyfriend of mine. His name is Tyler Woodell, Wedel. You can OSCN him and look it up and show his a fact that he owes child support.
That's just not relevant to this proceeding today.
The fact that he's trying to get out of paying child support because he got incarcerated.
I don't think he's trying to get out of paying child support. I haven't heard that at all. I don't know how you're hearing that.
The reduction in while he was incarcerated.
we're just talking about, he has been, and the amount owed is what's shown on your record of payments, unless he has the right to indicate he doesn't agree with it or something, that's not Mr. Hammer's understanding or the court's understanding at this point in time. It is, I don't know, is the rears an issue, or are you
No, Your Honor,
in
basically,
agreement with what the balance shows on the record of payments?
that's fine. I just, everything was fine. It's reasonable. I just didn't know, while I was getting charged.
How much is your current support payment?
It's $431.50. Yes, sir. And, you know, I don't mind.
And I understand you said you're unemployed, but I've also heard from Ms. Reynolds and yourself that
Yeah.
you're not employed by someone who's paying you. You're self-employed, in other
Yes,
words.
sir. Yes,
Is
sir.
that at
Yes.
this time?
Working on it.
Okay.
And
Would you be willing to, now I've heard from Ms. Reynolds, she had offered $100 a month.
Yes, and that's all. And they,
Well, would you be willing, Ms. Reynolds, would you be willing, could we round up to an even $500? That'd be 60-some. He indicates he could do that. Would that be agreeable with you?
yes, that meets us about halfway. I also
Okay.
wanted
Well, that
to
should-
ask about, never mind, I'll just dismiss that for now. It's just a question of whether or not we're, going to just handle the arrears right now, and that's all this is about. That's my
It's about
question.
that and the judge- It's about that and the judgment payment. There's no modification before this court today. So whether because he's not employed by an employer, he's self-employed, or whether he believes he is entitled to some different order for current support, he hasn't mentioned that. That's not before the court, so I
Okay.
think we should be.
My only other question is about the tax returns. He hasn't filed his taxes in about 5 years. And during the jobs where he was actually employed through a company that paid him with actual paychecks and W-2s and all that, he hasn't paid in over 5 years, which means that could be a healthy lump sum payment for our children, which would greatly help since I had a heart attack last year. I think that
Well,
our children
if
deserve that.
Yeah, if he didn't work for an, I don't know.
And if he's
That's not-
self-employed, does he not have to file a 1099
I
miscellaneous?
just filed
Well,
taxes
it's
Monday.
probably- Oh, you did?
Yes, sir.
Okay.
For the past 3 years.
Well, there you go.
Through tax techs
Asking you
in
shall
Tulsa,
receive.
Oklahoma. Yeah.
Well, usually when I talk to him, he doesn't talk back.
Okay.
But I did invite him afterwards to come see our kids for the first time in a couple of years, and I'm really hoping that he'll still do that and let our differences be set aside for them.
Okay, well, very good. Okay, well, he's, now I have sometimes entered an order. I don't know how enforceable it is about, requiring somebody to file their tax return and to provide a document. I just don't have the enforcement. I can't put somebody in jail. A district court judge has to do that for contempt of court. But he said he's filed them for the last 3 years, so we'll see what happened. Did you prepare them or did someone else prepare them?
Tax techs in Tulsa, Oklahoma.
Okay.
Yeah.
Are you doing any kind of a refund?
Not really. And I really owe the IRS $1,000, and then
Okay.
I think it's like $1,200.
For your fines.
Okay.
And then my
I
fines.
just wanted to let you know, Ms. Reynolds, so if there are tax refunds, this amount is certainly sufficient where those could be intercepted and probably would be intercepted on your behalf if that should occur in the future. Mr. Hammer, I think we kind of short-circuited things. I hope you're okay with that.
No problem, Your Honor. No problem at all.
I think we've got it resolved. Is there any issue that you
Other than, we do ask that provision regarding cash medical, establishing it at
Oh,
0 be
yeah.
entered.
I don't think either party has an objection to that then, so,
No.
so that'll be the order. I think since you both are in agreement on this, I would ask that you sign the order Mr. Hammer's preparing. So,
Okay.
um, Anything else, Mr. Hammer?
Nothing from the state.
Okay. Ms. Reynolds, anything else?
Nope.
Okay, you should get a copy since you'll be there and sign it. Be able to give you a copy. Now, I haven't signed it, they'll have to send it to me. We do it electronically now. So, I don't know if it'll get sent in today or not. But as soon as I get it and I'm available to sign it the next few days anyway, they can, Ms. Bellinghausen, do you normally, then once you get a certified copy from our office, then it's your office's policy to then send a copy to each party?
Yes,
Okay, so do you think they should have that within 10 business days?
yes, for sure.
Or, okay, is that enough time for you?
If not sooner,
You're
yes.
on- Okay.
Oh,
You probably will if you don't
address
get
of
this-
record. We did
Oh,
not,
okay, okay. And then the last
um,
few times that I've asked that, Mr. Hammer, the offices have all said that they've got an address of record, so
well, we may,
We do, I just have not placed in the order yet.
okay,
I think.
Never
well,
mind.
I think it's a good idea to ask, myself, just to confirm it, do each of you understand what an address of record is, what the implication? It just means that with an address of record, the agency doesn't have to serve you by a deputy sheriff or a process server, any future notice, or by certified mail. They can just send it by regular mail. So, Ms. Reynolds, do you want to confirm your address of record to Mr. Hammer then?
Yes, I live at 310 Split, like Banana Split Railroad, here in Enid, 73703.
okay.
1650
Mhm.
East Virgin Street, Tulsa, Oklahoma,
Okay.
74116.
Okay. Does that take care of everything now, Mr. Hammer?
I believe it does, Your Honor.
Okay, okay. Well, I appreciate the party's cooperation. I wish you both best of luck, and I hope your health improves, Ms. Reynolds. So I will disconnect. I'm going to turn the tape recorder off, and this concludes this hearing. So I've disconnected the